Okay, I'm Eric Schnapper. Well, at the brief writing stage, as I say, I'm focused very much on, from my point of view, on what legal standard I'm proposing. Conversely, if the brief for the opposing party isn't well written and it's not clear, I will focus on that mercilessly. And I've repeatedly seen briefs that have inconsistent formulations of the standard involved, and you can be absolutely assured I will spend several pages explaining how different they are, and that will then become a huge problem for the other side at the oral argument, because the Supreme Court hates that. So it's defensive in the sense that I'm intent upon coming up with something that's clear and administrable and consistent with everything else I'm going to say, but I also use it offensively if the other side hasn't done that right, and it is quite common to see that not done right. And at oral argument, again, I'll try to be as clear as possible. The court typically will ask questions probing the implications of the rule you're proposing, trying to suggest that the rule you're proposing would have consequences that really the court wouldn't be comfortable with, to see how you will deal with that. And if you then back away from your rule, and you can tell from the question and the body language you asked it that the questioner doesn't want the rule to apply there, and you say that, well, then you're in a world of pain because you've changed your rule. And so you have to have a well thought out rule, and then when you get there, you have to not only articulate it, you have to stand your ground and tell people answers they don't want. I argued a case a number of years ago about what constituted protective activity under Title VII, what kind of statements. And it was a case in which the specific issue was whether you were opposing discrimination, in this case sexual harassment, where rather than you're going to the company and complaining, they came to you and asked questions. And we staked out a general account of what opposing discrimination meant. And I was barraged with questions for about the first 3 or 4 minutes. I didn't finish a sentence as it went from one thing to another. And I kept telling them giving the court answers they didn't want. What if someone wore a button that said equal pay for women? I was asked incredulously, is that covered? And I said, yes. And before I could explain, someone else, even more aghast at what I said, asked another one of those questions. One came from Justice Souter, who, as I say, gone over temporarily to the dark side of the force. He came back, wrote an opinion our way, but you absolutely had to stay your ground. Once you had a standard, you had to stick with it, which meant you had to really think it through. Well, you certainly need to make a positive assertion about what you think the law should be, and it needs to be clear, and then you argue for it as best you can. If the other side has advanced arguments that that don't hold up, that's a significant part of any brief, and it could be about the clarity of their standard or any other weakness in their argument. And that's helpful in shaping the court's response. It's also helpful in driving the oral argument. I mean, to some degree, I will write a brief with the intent of encouraging the court to focus on a problem at oral argument. And sometimes it works and sometimes it doesn't. But the lack of clarity in the standard is certainly, someplace I'd always focus whenever I can. And it works, it's a remarkably common problem in briefs. They're both important. I heard Justice Sotomayor say a couple of weeks ago that briefs are particularly important because the court has a pretty good sense of where it's going when it walks into the room. But I've seen cases lost at oral argument. There's no question about that. It's at least as common to see a case lost at oral argument as won. It depends on the issue. And it depends how much the briefs really came to grips with things. Sometimes you walk into oral argument and there's just a lot up in the air and you're just going to get sorted out on the spot. Sometimes it's really well aired in the briefs. Nothing dramatically new is going to happen in an oral argument. So I think it varies. There are cases where the issues are just complicated and the court really is looking at the parties to explain things to them a bit more. A case I worked on a while back, the government lawyer, the government was on the other side, and counsel for the United States gave some explanation of a very technical issue, and the Chief Justice said, "Would you say that again, slower?" And that, that was, the oral argument was really helpful to the court in understanding what was going on. It was just very complicated. So it can be important that way. Cases do get lost there. That's particularly true if the court begins to go off on an issue that it just hasn't been briefed. And I've seen, I can remember one case in particular where the court just came up with an issue that hadn't been briefed, and the lawyer for my side just wasn't able to deal with it. And so we essentially walked out with no brief and no oral argument. You hope that won't happen, but you can't, occasionally the court will simply look at things from a different point of view than any of the parties did, and you have to be capable of dealing with it on the spot. No. There's far too much material in a brief to cover in an oral argument. And it's a very different animal. When I sit down to get ready for an oral argument, one of the tasks that I undertake is to pick out 2 or 3 points, most, from the briefs that I'm going to try to convey at oral argument. Remember, the vast majority of time in oral argument, you're answering questions. You typically have a minute at the beginning, maybe a few minutes of peace and quiet during the argument, a little bit of rebuttal that you can control, but not very much. The most that you can hope for is to focus on something in the beginning and try to get back to it in response to questions. So I try to ask myself, if there were 1 or 2 things that I wanted the court to remember when they get up and they leave, what's on their mind as they walk out of the room. A friend of mine said, well, she met someone on the elevator, remember the court on the elevator, and she could say something to them between floors. What would she say? It's just essentially the same thing, except it's easier in the elevator because you can actually get it out. But it's about as much time as you have. There are only 4 floors in the Supreme Court. So, 3 maybe. Anyway, so it's different. You draw on the briefs for information and citations and ideas, and it's a resource. But at the oral argument itself, you pick a limited number of things, and that's what you go with. And one of the most important things that you do is to try to figure out where you're going to start, which is the only part of the airtime you really control, and to try to frame arguments that will continue as long as possible before you get a question. The court, I think, traditionally will ask the first question about something you've said, and so it's important to try to not say anything that triggers a question too soon. I worked on a case once where I was just helping someone prepare, and he had 2 arguments, one of which was good and one of which was not going to work. And at our urging, he started out by saying, well, we have 2 issues, A and B, and I'd like to focus on A. And the court said, let me ask you a question about B. And he never got out of B, and he lost. Now, a more experienced lawyer could probably get to A, but you have to really know what you're doing. And so I try to avoid that sort of thing and to think through the sentences in a way that in the very first sentence, the court knows what I want to focus on. I've heard other people try to, in one sentence, get across their 4 arguments. I don't think that works because I think it's 4 different things, and you lose track of, the court loses track of stuff. They want to know your 4 arguments. They've got a brief for that. I think my job is to figure out the one or 2 points I want to make and focus on that. Well, the brief and oral argument are different. I mean, when I'm writing a brief, I want to have a clear standard, one I think the court can live with, and then I want to marshal as many arguments as I can for that and criticize the arguments and the standard proposed by the other side. I'm not worried about what the priorities will be at oral argument. You can't know that when you start. There's an interaction and interplay between the briefs as it goes forward. And what the critical issue is often you can't know till the last brief has been written, you've taken a week off, you've thought about it, and you come back and go, it's really come down to this. It's like, who knew shortly after the Confederates filed in Fort Sumter that Little Round Top in Gettysburg was very important. It turned out to be critical to the outcome of the war, but until the armies engaged, nobody knew that Little Round Top mattered. There's a certain amount of that in appellate litigation. At the end of the day, each side makes arguments, they concede things, they don't advance certain arguments, and it comes down to things that you would not have known at the opening stage of the briefing were the critical points. Sometimes you could have guessed and you'd been right, but if I think about the cases I'm working on now, until I've written my brief, I'm respondent in the case I have in mind, and I've seen the other side's reply brief, I don't know what this has come down to. Now that's if you're the petitioner. If you're the respondent, it's even different, very different than that, because everything changes in the first 25 minutes. You see what the other side's arguing, you see who's buying it, you see who's not buying it, and often as a respondent, you get up and you figure out your argument on the spot, which again is one of the reasons why people having experience is so important. If I'm working with a lawyer who hasn't done this before, on the whole, we'll identify a couple of themes, we'll go over some questions, and you just hope against hope that that turns out to be relevant to what's going on when the argument happens. But if you've got the experience to be able to, it's a little bit like audibilizing in football. Then you see what's happening with the defense, you see the strengths and weaknesses, you see who's saying what, and you might get up and picking on a theme that you never dreamed of focusing on, saying, we agree, Justice Kennedy, with your point, that. And you can see why that would be really effective, but you can't foresee any of that. So the oral, aside from the need for clarity of position, oral argument's not typically on my mind when I'm writing briefs. If I'm preparing for an oral argument, just the way they say battle plans never survive contact with the enemy, oral argument plans never survive contact with the court.